Welcome to today's podcast. I'm joined by Chris Mammen of Womble Bond Dickinson. Chris is an expert in AI for IP and has talked on the topic and considered the topic in a range of different forums. And I think that there's a lot of discussion around AI ownership, inventorship at the moment for IP rights and how they interact. So welcome, Chris.
Thanks for having me in today. It's always good to see you.
I will kick off with the first question. So AI is a really broad term. Looking at IP ownership in the work product of AI is a controversial topic. Can you outline the questions around the current law that are being raised by AI work product?
Sure. So let's start by saying that AI in various forms has been around for a long time. There are sometimes referred to as extractive AI or analytic AI. And that's not what we're talking about in this current round. Starting about 18 months ago, generative AI came onto the scene. And what generative AI is uniquely able to do is to mimic human recognizable outputs, whether that is text or visual images or music or audio files, if you will. So it's been able to generate these outputs. And the way it does that is by ingesting loads and loads and loads of human created work and learning how to mimic those things. And so we have a variety of questions that are coming up right now, particularly in the copyright context, about both the inputs and what the copyright issues are surrounding the inputs of all of that human created content into the AI, as well as some questions about copyright and the outputs and what kinds of protections or infringement risks there are on the output side. And so it's useful to talk about both of those as conceptually separate topics. There's also, as you know, some interesting questions on the patent side that have been driven largely by Professor Stephen Thaler and his AI algorithm Dabus, for which he's tried to get patents around the world over the last several years. And so we can talk about that as well. So on the input side, what we're seeing at the moment is a lot of litigation, mostly in the US, but there are a couple of cases in the UK as well, arguing that the act of training an AI using copyrighted material is unauthorized copying that does not fall within the fair use exemption, which is something that exists in U.S. copyright and in some analogous version in other copyright schemes around the world. And we don't know the answer to that yet. It's a question that is being actively litigated as we speak. There are something like 24 lawsuits pending in the U.S. brought by computer coders, visual artists, musical artists, and of course, authors. And so we're watching those cases with great interest. There are a couple of cases focused on copyright issues on the outputs. And the two that I will mention, there's one that was brought by Getty Images, and there's one that's brought by the New York Times. The Getty Images case has counterparts pending in both the US and the UK. And in large part, these cases focus on a problem in AI referred to as memorization. That is, the thing that comes out of the generative AI looks uncannily like one of the copyrighted or protected inputs. And so if something passes through and is more or less an exact copy on the output side, there's an argument that that's unauthorized copying. There is, I suppose, below the surface on the output side, a question of whether using the copyrighted inputs and mixing them up in some fashion so that they generate some hybrid, they are contributing ingredients to some hybrid output may also constitute copying. That question hasn't really come up yet, and some of the AI platforms have tried to preempt that conversation by issuing promises that under certain conditions they will indemnify users of their platform if they're accused of copyright infringement based on entering prompts into the AI platform. There's a lot of detail in that, and I don't want to go into the detail, but that's sort of on the copyright side, the inputs and outputs. One other thing that's unique to the UK that's really interesting is that since 1988, there's been a special provision in the UK Copyrights Act that allows for special copyright of a shortened term for computer-generated works or machine-generated works. I'm not entirely clear on what was going on in the 1980s to prompt Parliament to add that to the UK Copyright Act, but it's an important difference between the UK and many of the other economies around the world, including the US.
Thanks, Chris. You talked about inputs and outputs, and I've been considering the risk of AI output and use in business. So these generative AI systems, which are trained on the data lakes of third-party information, what are the risks to business of using AI to generate content for their business?
So there are a couple of risks associated with this. The first one that I would mention is this risk of memorization that I mentioned in connection with the New York Times and Getty Images cases. If a company is using generative AI to create content, there is some risk, I can't quantify how much of a risk it is, that the outputs could be memorized from some copyrighted material. There is a risk that there might be some user exposure on the fair use input side that sort of passes through to the users, depending on how those cases involving fair use and copyrighted inputs come out. So there's some risk there. Another risk or another thing to keep in mind is that the copyright authorities, other than this special provision in UK law, copyright authorities have generally said that AI-generated works cannot be protected. And so if a company is using generative AI to write advertising campaigns or write computer code or create images for use in marketing materials or whatever, those may not be protectable as copyright. They may be in the public domain, and so there's a risk of that stuff then being free to use by others. And then the sort of fourth category of risk that I would want to mention is that to the extent that companies are themselves content creators, the widespread use of AI, and if it's determined not to be barred, or if it's determined to be protected by the fair use exemption, then there may be a significant impact on the market value of the content created by traditional content creators. So in other words, if a company is not only using generative AI to create outputs, but also owns copyrights in materials that are out there and potentially used as inputs, if there's currently a market value for those materials, that market value may go down. And so there's a risk of loss of value for that created content.
You mentioned that in most jurisdictions that AI-generated content was not protectable by copyright. Could it be protected as a trademark if a business has used AI to generate content in that way?
In theory, the kinds of things that are protectable by copyright, if they're used in commerce and have some values sort of identifying the brand, in theory, it doesn't matter whether it was created by an AI or an artist or random. And so there is a narrow window for protection of things in that way. But in terms of sort of broadly talking about protecting content, it may be, or it is for now, fairly limited. The reason for that, at least articulated by the U.S. Copyright Office, is that the amount of creative activity that goes into typing a prompt into a generative AI platform isn't sufficient creative control over the outputs. You know, if you go into something like DALL-E and you type a prompt in, it'll give you 4 outputs. And then if you type the same prompt again, it'll give you 4 different outputs. And you don't necessarily have that much creative input as between those 4, 8, 16 outputs. And so for now, the Copyright Office has said that level of creative input is not enough.
Thanks, Chris. Let's move on to talking about inventions and patents. So in AI generated inventions, there have been the Dabus cases in a number of jurisdictions, but what is the current sort of thought process around inventorship, and can AI itself be an inventor?
So I'm not aware of any jurisdiction in which there has been a determination that an AI can be an inventor. The one place that Professor Thaler and his team have prevailed in getting a patent issued is South Africa. And in South Africa, the process of obtaining a patent is more like copyright registration or trademark registration, in the sense that there's no substantive examination and there's no requirement to name an inventor. So Dabus's patents have issued in South Africa. Every place else that the applications have been filed, the applications have been rejected because an inventor has to be human. In the U.S., that determination has gone all the way up now to the Supreme Court. The Patent Office rejected Thaler's application. Thaler challenged that in the federal trial courts. Trial court rejected it. That was appealed to the U.S. Court of Appeals for the Federal Circuit, which also rejected it. And then the Supreme Court declined to hear that case. In the UK, the outcome was the same. There's a determination that an inventor as named on a UK patent application has to be a human. There's a slight difference, though, in the UK process, which makes it a much narrower case in the UK. The application form says you need to name the inventor if you know who it is, and whoever you name has to be a human. If you don't know who to name as the inventor, then you as the applicant have to say how it is you came to have the right to file this patent application. And so this created some interesting conundrums for Professor Thaler, who really wanted to list Dabus in that inventor blank. And the courts all the way up through the UK Supreme Court said you can't put Dabus as the name of the inventor. But then Thaler's fallback was, well, I, as the owner of the computer system on which Dabus is installed, have what we call accession rights to whatever the outputs of Dabus were. And so therefore, if anybody can apply for a patent for what Dabus came up with, it's got to be me. And very interestingly, both the UK Court of Appeal and the Supreme Court went all the way back to Blackstone and the writings of Blackstone to talk about this law of accession. This is the idea that if I own an apple tree, or if I own a piece of property and there's an apple tree on that property, and the apple tree produces apples, I also own the apples as the product of the tree. And the courts said, well, that may well apply to apples, but it does not apply to intangibles like an algorithmic output from an AI that happens to be on a physical computer that you own. So it's sort of an interesting twist between British legal history and this new question.
I think the accession point was quite an interesting argument, and I think actually maybe slightly different, because although you may own the physical computer, you might only have a license to use or a limited license to use the software, and then the argument would come down to who owns the actual AI. And then it could be that the company that's developed the AI is only a lot of inventions.
Yeah. Yes. You're right. It is potentially much more complicated in many cases than the apple tree example. And so it probably was not a bad idea to steer clear of drawing that analogy.
So I think I blurred who is the inventor into who owns the output a little bit in the last sort of comment. But what's the current position in terms of who would own the output of whatever the AI has produced? Because if there are terms and conditions of the AI platform which say that, is it a contractual sort of ownership? So the terms and conditions say that the company that invented the AI will own any output, or that the user will own any output. How is that being dealt with at the moment?
So that's a really interesting question. Let me start with this provision in the UK copyright law, which says, and I'm going to quote this imprecisely, but it says something to the effect that the owner of the copyright in the computer generated work will be the person or entity responsible for making the arrangements for the work to be generated. And it's sort of a mouthful of how it's articulated, and it's not at all clear in today's example of whether that means it's the owners of the computers or the owners of the software or the person who enters the prompt, or if it's shared in some fashion. So I think that there will likely be some further analysis of that question as we move forward. You raise a good question beyond that. If we're not looking at that particular instance, who owns the outputs? There's no IP rights in those outputs. So from that perspective, in the US, they go into the public domain. They're not owned. That does not necessarily answer the question as between the platform and the users, if there are contractual terms and conditions that specify that as between the two of them, one owns or is entitled to use, that may be the case. And so to the extent that there are rights in this as between other private parties, you would need to look at contractual rights. It'd be a separate question as between the parties involved in use of the platform and third parties who may find one of those images or a piece of AI generated text online. To what extent can they freely use it and have some liability to either of those parties? That could be a third party beneficiary question.
Recently, the USPTO issued some guidance around inventors and AI. Perhaps you could just step us through what that means.
Sure. The guidance that's issued in early February 2024 from the USPTO really doesn't change the status quo, and it may serve to clarify the status quo a bit. The two items that have come out in the past couple of weeks cover first the responsibility of practitioners before the U.S. Patent Office to make sure that whatever they submit to the Patent Office is truthful and accurate, regardless of whether the practitioner used AI to generate some of that work product. And that just reiterates that the human who puts their signature on the document before it goes in is responsible for what's in that document, regardless of how it was created. And that's a common sense solution and existing doctrine solution to this new technology. Similarly, in the invention context, the Patent Office has issued some further guidance that reiterates that AIs cannot be named inventors, should not be named inventors. Humans who work with AIs, using them as research tools, should be the named inventors if they qualify under existing guidelines for being named inventors. So I would venture to say that in most instances, there will be some human involved in the process who has a level of participation that qualifies under the existing standards for being a named inventor. There may be less quantum of human involvement in the inventing process than there might have been in past years where multiple humans are named as inventors. But, in those instances where there's a team of multiple humans, there may be some who have a very limited involvement, but it's across that threshold that suffices to be named as a human inventor. That's the same threshold that applies now. We can imagine that in the future, there will be an artificial general intelligence that comes up with stuff such that there are no humans in the loop that can be named as an inventor. That question is not currently addressed by these recent clarifications by the Patent Office. But for now, the humans who are involved in the process are the ones who can be named as an inventor, and they have to have the normal, usual requirements for being named as an inventor.
Thanks, Chris. So it sounds like an iterative process as the technology develops.
Yes.
So my last question, there's a lot of discussion around the rapid development of AI and the capabilities and the potential for AI in the future. I think what everyone's concerned about is AI going to render us all out of a job?
I'm optimistic that that's not going to be the case. Every industrial revolution, and this is really appropriately thought of as another industrial revolution, changes the mix of jobs, changes the mix of things that humans do and the ways that we participate in the economy. But we have continued to grow. The kinds of jobs change, and there will be new jobs that we haven't even thought of. And for now, the final step, as we were talking about with patent office practitioners, the final step of having a human exercise human judgment as the last step in the process is still there, and I think is firmly still there, even as these technological developments help us do our jobs better, faster, and cheaper.
Perfect. Chris Mammen, thank you very much for joining me. That was an excellent discussion.
Emily, it's always a pleasure. Thank you.